Hello. I want to welcome everybody that sees this. This is going to be a sort of a pre-trial practice run for me. I'm going to use this as an opportunity to continue to address my case in good faith and to address the issues at hand. And we'll be starting up in just a second. We'll wait till there's anybody in here. This is unrehearsed, so bear with me. This is a true live stream. And there will be aspects of this that are, not trial friendly. Because I'm, at my house. I think it's really a great thing to share my experience as a pro se litigant with people. I think that's actually like an exceptionally good use of my First Amendment privileges. A lot of this stuff is public record. Well, the case is all public record. If you want to dock it, I'll give the case number if anybody asks. Sharing it. Because I think this really should be seen, I'm doing everything I can. I'm doing everything I can to, I got this jacket on. Obviously, court, you're not allowed to wear any sort of logos or anything like that. So I would wear probably a white shirt, something more professional, essentially. I guess there will be some piano playing, some music. There will be a little bit of an event. It's going to be fun. We're going to have fun. It's going to be a fun time. I realize the reporting system on YouTube is just insufficient. You can make VPNs and you can make aliases, and there have been quite a few. I will say that all of the intimidation has already been filed with the court. The Brett has HIV. That username has been a lot of their communications have been filed in an ex parte. It's basically I don't have to share that with the it's ex parte, and it's me to the judge. It's possible. I don't know if I fully. Okay, so when you do a judicial notice, an ex parte communication for judicial notice. So what's the point of that? It's to alert the judge of facts that are relevant to the case, right? Facts. Now, I think it's obviously law is an evolving subject, so we have to contend with the fact that it can be interpreted, in different ways with different judges and different courts, and different courts have different instructions. I'm not sure of it, but I do understand that there is something about civil procedure which it asks that you not amend, or you're not allowed to amend without motion for leave to amend, like a second or third time. After reading the court instructions a few times, I could be reading it wrong, and I should definitely do my diligence because it's that important. I've read these court instructions quite a few times. Now, first and the most important thing, that's probably okay right there. I believe as a pro se litigant, the most important factor is that you read the court instructions, because then you can follow them, and then you can you have to kind of vibe with the court. You have to kind of vibe with what they want, and as a pro se litigant, there is leeway. Now that's a precedent, so it's known that there is leeway for pro se litigants. However, pro se litigants are still technically held to the standard of a lawyer, technically, but the courts are allowed to make, especially in good faith, they're allowed to make exceptions that are, if it's non-frivolous or vexatious, then they're allowed to, operate as they please. The judge has his own leeway. So I got leeway, the judge has leeway, everyone's got leeway, but there's also the court instructions, which are, you basically want to follow them, and I've done my very best to follow them. I will say my first complaint was actually not improperly filed. It was filed correctly, and it wasn't e-filed. I mean, it was filed and it was filed through the internet, and then also mandatory chambers copies were provided. And then I amended that complaint. So I would say the first complaint was a bit of a mess. It was done under duress, as literally all of this stuff has been under duress. I've been under duress this entire time. However, I'm strong enough to sort of like maintain and continue and do my best. At times it's difficult. There's been a lot of, as a pro se litigant, I would advise you this. Depending on your case, it depends. How important is it to you? How important is getting justice on it to you? Because when you do go into it, it's not necessarily fun, and it can be quite painful. It can be because as a pro se litigant, depending on what you're dealing with, you might be having to engage in a lot of your own trauma and a lot of negativity and about you. But you're acting as your own lawyer, and thus you're required in some sense to do the diligence and to actually look at the evidence. And it's not that part, has been the ADHD, doesn't really help. Well, it does in some cases, I think, because they say that people with ADHD they hyper focus. So I think that in some sense I've been hyper focused on the case, but also there's also the fact that I would not have filed this unless I was literally cornered to a wall. And that when I after talking to my therapist for months, and then the resuming of the harassment and the tormenting via channel that's currently called Hell to Pay, which is an insinuation, I believe, that I have a to pay, which honestly, if I did, I don't think it's relevant. I think it's blatant bullying. I don't think it's funny either. I think that my grandfather wore a toupee for a while, and he was one of the most lovely people on the planet. I don't personally, I don't appreciate any harassment on looks or anything that you can't help. The teeth, the dentures, I really did not appreciate. I didn't appreciate that being said, because it's so cruel, it's so unsympathetic, and so and dental issues are a serious problem in the world, and people experience them, and it can be traumatic for them. And when somebody attacks somebody for having dentures, it sort of reiterates and promotes this type of behavior that I think is vile. I think it's grotesque, and I think that people with dentures are fucking great people. They're still people. You don't lose your civil rights because you have dentures, first of all. And even if I had dentures, it's still bullying. It's still bullying, because because of the intent. It's malicious intent, quite obviously. Now, that said, if anyone here has dentures, I welcome you, and I understand the pain that maybe you went through, and I am sorry. I'm sorry for the defendant's behavior, because you don't deserve to be mocked or trivialized or in any way just because of a basically what amounts to a health issue. That I understand very well what it's like to go to a dentist and to not have the money, and to the stress involved, and also the embarrassment, the self. Like, it's very, very, very important to me that I stand for people that may have dentures. Honestly, I can't express that enough. That I don't want to see any. It's not. I know some people might be able to trivialize it in their heads. Maybe they haven't had dental issues. Maybe they have. I don't know. And I know it's not an uncommon attack, but it's, in my opinion, it's very hurtful, because it promotes an environment of and I'm going on with it and talking about it at length, because I'm actually doing that on purpose, because I want to express just how much I disagree with the practice of using something like that as an insult or any type of negative insinuation. Your teeth do not define you. You define you. Now, that said, we live in a society where looks matter, I suppose, but for me, you're good with me, and I support you. And you can look good with dentures too. There's also, like, implants that you can get that are sort of like dentures, like they're like implanted in. And I hope one day to have some sort of charity in place, because of my own experience with dental trauma and issues, to have some sort of organization that provides anybody. Now, the thing about dentistry is that even people of means can really struggle to afford it. Like, I'm a person of means, but getting dental implants, I have 2 dental implants. It was very, very expensive, and it was something that had to be paid over time on a credit card. And it was not fun. My partner had to pay for it mostly, and it was expensive. I think I earned the money for one of them, and then for the other one, I get it, and you are not any less, if you have no teeth or a bunch of teeth. Your character is what it matters, not your teeth. Okay, you're not, so I really do. I mean, it's worth the time spent discussing, because part of this case is actually about human suffering. It's really about how do we prioritize human suffering? What do we do about it? Now, in this case, for 2 years, I have suffered numerous defamatory attacks, cyber stalking, and cyber bullying, as per the Federal Conference of Legislators, because there is a channel in question. I think I referenced it. It's currently called Hell to Pay. Now, the to pay part, everything I said about the dentures goes for the to pay. It's just not okay, in my opinion. But this said website, or blog, however you'd like, it's a YouTube channel, which is sort of both, was designed to torment, harass, and otherwise harm. It was an IIED, intentional infliction of emotional distress, which is I believe it's both a civil tort and a criminal matter. Anyone could correct me if I'm wrong on that. I'm pretty sure that it's both. You don't want to intentionally inflict emotional distress on somebody. It's illegal. It is. And in this case, we do have a defendant who admits to this behavior, fully admits. There is a transcript of and a video, corresponding video, which has been downloaded and transcribed via professional service. So the thing about transcripts is that I believe you want them on lined paper. See, there's like 1, 2, 3, so that you can cite them in your complaint or in your motion or whatever. And so you want to cite the line of what you're talking about. I think so when you're compiling evidence or exhibits or citations or anything that's going to be used to argue your case, a lot of the time, if it's written stuff, you want pleading paper with numbers. So the only thing lacking in the transcript currently is the pleading paper. It's not currently put on pleading paper. However, it is professionally transcribed. I believe, and I think this is something worth noting as a pro se litigant, that the better you do, the better you do. Okay, so the more good faith you offer the court, and provided that what you're saying and implying and insinuating and demonstrating is true, that's part of it. So if it's false, on its face, it doesn't matter how professional it is. It's illegal, or it's not. Wait, I don't know if illegal. It's violation of procedure, basically. It is. You don't if you're lying to the court, it's illegal. You don't do that. So this is the second amended complaint. I think there's been some discussion of whether or not this is public materials. I know that there's been videos made where it's been blurred out. However, my address is on there. My address is not hard to get. Okay. And honestly, most people's addresses are not that hard to get. There are apps. Been Verified is one where you can just look people up, and so it's public record. My address, essentially, I think it would constitute public record to some degree. And it's my address. So there's one other person that really has a say about that. Now, if you know my address and you use it to in any way violate my civil rights, that will be adjudicated. I will sue you, because I will not tolerate any of that. Not even a little. So I'll just let anybody know that ever wants to come by or anything like that. If there's any type of behavior where you're near my house and then you're approaching me because you know my address, that will be considered stalking. And even one instance will be sued. So even in one instance that I know of anybody using my address for anything, and this is not what I'm going to say in trial because that goes up saying in a courtroom. So I'm just letting anybody know. Anybody know. I don't care what you think I've done or what you think what you're entitled to. If you have a problem with me, I would advise you to first email me. positivemomentumwithtodd@gmail.com is one you can use. I would advise you to send me an intent to sue if that's your intention, or you can just send me a letter that says, "Hey, we have a problem here. I don't like what you did," and then and then we can go from there. Ideally, we can mediate. And I gave Mr. Holmes, one of the defendants, and I believe Mr. Thompson. Mr. Holmes definitely had some time to speak to me to potentially mitigate some of the damages. with just good faith conversation. And under civil procedure for that matter, let's find it in the court instructions. All right. Okay, so the case has been assigned to the calendar of Judge John A. Cronstadt. Both the court and counsel bear responsibility for the process of this litigation in federal court to secure the just and speedy and inexpensive determination of this case, as called for in Federal Civil P1. All parties or their counsel are ordered to become familiar with the federal rules of civil procedure, the local rules of the Central District of California, and this court's standing orders. So this court has its own standing orders. There's the standing orders is the court instructions. Okay, so there's already one there, an insinuation of inexpensive. So when they say inexpensive, you're using court resources when you file. Period. Judges are being paid. Everyone's, you're costing money. So ideally, let's see. They would like to see mediation outside of court. That's just, it's an important thing to note. I'm not going to read the court instructions, but I will advise anybody that's involved in litigation to seek out. So, I believe in here's a pro se mistake. I executed a summons that was not I think either preferred or necessary one to serve, to use the form. It was the wrong form, and I believe it to be now the wrong form. So it was the Sum 100 form. Now, which gives it does advise the defendant they're being sued. It is potentially legally binding. However, it's potentially also not going to be filed by the court, being that this standing order, I believe, I wonder if it mentions, let's see, it does mention service. Okay, so the plaintiff shall promptly serve the complaint in accordance with Federal Civil Procedure 4 and file the proofs of service using the court's civil form CV001. Now, what form is that? I believe it is this proof of service, which is attached to the AO 440. I believe. Hold on, let me see that. Well, this is the AO 440. So, court's civil form. See, this is why you read, because I need to make sure that I do that. What is the court's civil form CV001? All right. Court procedures. To make a mistake isn't. I mean, it may constitute a violation of civil procedure, but it's not a crime to make a mistake. In good faith, it's not a crime. It's not something you want to do. You want to avoid it, but it's something that I think, as a pro se litigant, you might be more inclined to have the judge consider. Proof of service. Okay, so this is the form I need filled out. It's funny because there are several, so that's something to note. There are several service papers or forms. And that, if you don't, you want to get the correct ones. And look, I got the wrong one. I served Michael Thompson with the wrong form, period. And now that needs to be amended. Now, I do believe that some of the court instructions could be made a little more clear, because I know this is the one issued by the clerk, and this is the one that has to be used, even though it doesn't say it. It's what was issued by the clerk, which is it's not perfect. The system, there's no system that's perfect. So you have to do your best. That's my number one tip. Do your very best to present a good faith argument. It's very important, because doesn't go unnoticed. So the defendants in this case are Mr. Michael C. Thompson, Mr. Gregory Holmes, and YouTube LLC. Okay. I think some people say they like to start with the hardest first. So, but then again, is it wise for me to, I don't really like the idea that it would be unwise for me to tell my strategy, because it's all based in truth. I mean, I think the best legal cases are based in truth. They're based in the facts. They're based in, or they can become, they're organically, so the complaint and everything that's followed arose from a set of facts, a set of situations and circumstances. And that's good faith, right? Is to tell the truth. But I think that also when you follow the truth of what you know to have happened, it will lead you to strategy, essentially. That is, so I wish that, I don't have a legal counsel, so I doubt they would advise me to say this, but I believe that YouTube LLC is not immune under Section 230 for two reasons. One, I believe, now I'm not positive, I would have to look at, I would have to most likely compel some evidence or in discovery. I believe that Mr. Michael C. Thompson has been kicked off of YouTube before. Because Mr. Thompson has created many channels. Several, if not all of them, are dedicated to tormenting individuals, which is already a violation of the terms of service. And before I even tell you what the number one is that, this is number two. We'll start with number one. So in the event that Michael C. Thompson was banned or did have an account banned at any time, then YouTube would be liable and not immune under Section 230 due to failure to uphold promissory for estoppel. Now, what does that mean? Estoppel. It means to stop somebody, right? And what does promissory mean? It means promise, like it's our duty. Like, I promise I'll stop. Promise to estoppel. Now, if they have a promise to estoppel, so if YouTube if it is true that YouTube has a promissory for estoppel on Michael C. Thompson using their platform to create these channels, then they didn't do that clearly, because then we wouldn't be here. So that's number one. Now, you have to understand, Section 230 has been upheld 95% of the time, about maybe not, I don't know, something very high. It's been mostly upheld. There are a few cases where it has been deemed not immune. So like where the courts have said you're not immune, and that goes for, it's not just YouTube. In fact, I don't know that YouTube has ever. I'm not sure if YouTube has ever had a Section 230 non-immunity. But another pro se litigant tip: Most YouTube lawsuits, in my estimation, now I saw one, but I'm going to suggest that I think that a lot of the suits are thrown out, not even due to Section 230, but due to filing in the wrong district or venue, or the wrong jurisdiction. So what's the right jurisdiction for suing YouTube? Northern California. Now, you want to sue them in the Northern District of California. So the question is like, first of all, with the law, it's a creative endeavor. So ask yourself, is that fair? Is it fair for YouTube to have is it fair for someone in Louisiana to have to file in the Northern District of California? It seems a bit of an undue burden. However, it has been upheld by courts and things, and there are complaints that have been thrown out immediately upon that. That said, I have not filed in the Northern District of California. I'm aware of that. However, I have asked, due to the adjacent nature of the two districts, Northern and Central, and the weight of evidence, and as well as in order to not create undue burden on me, I've asked that the judge allow this case to go forward in the Central District of California. I believe that that is fair. I believe that it's YouTube has offices in Los Angeles, and Google does at least. And so it's probably fair to say that they have, means. Well, they have means, obviously. That's not even in question. But they have a base here, So it doesn't really create too much of an undue burden for them to move venues, especially in this instance. Now, again, if I was in Louisiana, they would probably have an argument. It's because of their terms of service, probably. Yeah, I say probably because it's a strange rule that they're allowed to self-impose where they can be sued, even though that they're operating in every district. So, but you'd have to you can challenge things. You can challenge rules and stuff like that. That's what courts are for, basically. So that said, it is possible that that YouTube moves to dismiss based on lack of improper venue or jurisdiction, and it is possible the judge says, "All right, sorry, Todd, it's dismissed against YouTube," and they could sever the parties and say, "Todd, you have to go sue YouTube in the Northern District," which I'll do. And then it would be a bigger burden, I suppose, though we do live in a digital age, and it may not constitute such a big burden. However, I would like to keep the parties joined. I did not file a joinder. There's a term. I would like these three parties to be in one case because I think that it promotes the public good. Because to demonstrate a potential conspiracy, cyberstalk or cyberstalking, it would be best to have all the relative parties relative to my case in the same case. Now we'll see what happens with that. I believe there's a decent chance that I'll get the relief. So that would be relief for me. So you're asking the judge for relief, like, hey, come on, give me a hand here. And so, and you're hoping that you get it. So we'll see how that goes. It's not violating civil procedure to request that type of relief from, having to file in the Northern District. But you have to ask, and the court has to approve. And it will be incumbent on YouTube to say, move to dismiss based on jurisdiction, which is possible. It's happened before. And there's a case, Romney versus YouTube, I think it was from 2019. He filed in New York, and YouTube moved to dismiss based on lack of jurisdiction or improper venue, and they got it dismissed And honestly, the funny thing about that is I can't even find the complaint. I've done some searching. I don't even know what he was complaining about. I don't even know what the issue is. All that's noted from that case is there's this venue issue. Now, state law is state law. So state law is state law. What does that mean? It means that Northern California law is the same as Southern California law. Now, the court instructions perhaps are going to be varying from court to court, from judge to judge. Now, but the civil code of California is still applicable in both venues, which is another reason why it's not such a preposterous request, in my opinion. Okay, that said, okay, so the court instructions. So let's look at that, because honestly, if there could be some sort of imperfection there, or some sort of blind spot, so to speak. Standing. That's what I dropped, isn't it? All right. Service of the complaint. The plaintiff shall promptly serve the complaint in accordance with federal civil procedure 4 and file the proofs of service using the court civil form CV001 pursuant to local rule 53. Although federal civil procedure 4 does not require the summons and complaint to be served for 90 days. Okay? That's really, really important. 90 days. I have 90 days to execute summons. That's called. It's when you have achieved the service. It's called executed. You've executed summons. That's what you would submit to the court. The court does expect service as soon as service can reasonably be. This is not. Where's 4 here? Huh? That's why you don't want to drop any papers. You want to keep them. Oh no, this is not a good look for the court. Where did instructions? Wait a second. 2, 3. So I need 4. Where's my page 4? Didn't I? Now, what's going on now with me? So physically, you've seen me kind of, I'm looking for something. And that's not really a great look when you're trying to assert a case. But this is practice, folks. This is a practice. And I have a copy right here stapled, which is a good thing. So if you're going to staple for this court, you want to staple in the upper left corner, right here, so that that's important. Pagination. What is that? Page numbers. It says here. I see, and that may have been an imperfection in one of my filings. Is I improperly paginated. However, there's legibility. They were legible, so that's good. So if it's a mess, I saw a complaint from a woman, I think, against Cardi B, YouTube, and basically everyone in the industry, that was scrawled with pen and illegible and it just didn't make sense. And so it was dismissed because it didn't make sense. So as reasonably can be accomplished. So, okay, what is reasonable for me to accomplish service of the defendants? Well, that depends on a few things. One is that this is a case where I was caused a great deal of emotional damage, and I experienced a great deal of trauma. So engaging in it is not always easy or reasonable for me to do. I need to rest. I need to give myself breaks. There's a syndrome associated with litigation that is clinically observable, and that's an important thing to note for yourself if you're going to go through it. But that said, I have already made attempts to serve YouTube and Mr. Thompson and Mr. Holmes. No, not Mr. Holmes. I don't think I've. If Mr. Holmes is willing, and if he happens to see this, I can fax or send you a waiver of summons, or I can email to you, and you can fill it out and return it at your whenever you want, I guess, if you want to do that. But I need to make an attempt. So if at 90 days you haven't made any attempts to serve, you're going to get dismissed because you didn't do what the instructions said. But if you've made like 5 or 6 attempts and spent like $500 doing it, the court's probably going to say, you can serve them through an email. Like I requested for electronic summons, maybe too hastily. And I don't think it was even filed because I was a little bit under duress and thinking this person might evade, and I didn't want to spend more money because it just felt unfair. Because I feel like, you should engage, even if you're a defendant, especially if you're a defendant, you probably want to engage the court in as good a faith as possible. And that means, responding to the plaintiff, or plaintiff's counsel, in this case, me. That is going to look good for the judge. That I am telling you, that's a good look for the judge. Even if you're a defendant, you're going to mitigate your damages potentially, by just giving good faith. So presence of lead counsel, lead trial counsel, court does not. I think we were talking about Section 230 and there being a second issue, negligence. Promissory for estoppel is it is a form of negligence in my opinion, but negligence, failure to warn as well, I believe, is apt here. I believe and that's 3. That's 3. They're all negligence essentially, but there are some differences. So what is failure to warn? Well, does anybody know the McDonald's hot coffee case? And I think a lot of us know that. And I think that any of us that have seen videos on YouTube about it or actually looked into it, we know that it wasn't just some frivolous lawsuit. This woman, I don't know her name off the top of my head, had serious injuries because this coffee was, I believe, upwards of 190 degrees. And in my opinion, even in my personal opinion, even with a warning, if you're handing people coffee at that, that's dangerous. So, but what happened? There was a precedent set where McDonald's added caution hot coffee, and that's because they had a failure to warn. So in my opinion, YouTube has a failure to warn about cyber stalkers. I believe that especially in live chats, especially in the live streaming, I think that it may be there, but was it visible? And I'm not saying it was there or is there, because I don't actually recall seeing anything about cyber stalking in the preface to live streaming. There is the ability to not have a live chat, to limit your live chat to subscribers only, which, isn't really much of a deterrent if you think about it, because you could just subscribe and then you're in the live chat. And it's not like I have blocked, I can't block, screen names I don't know. And then there's also you can select who can. You can actually type in one specific names and say, these are the only people that can talk. Now, why am I using YouTube in the first place? I'm using it to promote myself, to create content and promote myself, and to potentially make money, and to create content so that I can pursue a career in the arts, or also a place to practice my First Amendment and utilize it to the extent that it benefits me. So talking and engaging with people in good faith generally. In bad faith leads to lawsuits. In good faith leads to learning, right? Which is important, which is like a public good. So live streaming, as far as I know, is my First Amendment right to say what I'd like because it's my content. But you will be held liable for what you say. So if you lie, you will be held liable for that. So if I have lied, I will be held liable in this case. That will hurt my case if I have lied. Okay? That's true. Obviously, it's going to be like, well, what did you lie about? Did it hurt? Did the lie cause harm? Was there a duty to honestly, I don't believe that you have to tell the truth. There's no law that says you must tell the truth. But depending on what might happen as a result of lying, telling the truth is a better option potentially. But there are some cases where your personal body, you might be endangered by telling the truth, in which case lying is not, so that's not illegal, right? To lie. Okay. So where you can, in reasonably safety, with reasonable safety, tell the truth, but if somebody is, first of all, if somebody is cyber stalking or harassing you, you have no duty to tell them the truth. You have absolutely no obligation to tell that person the truth. None. I actually have no obligation to tell the truth on this platform, as a matter of fact. However, I generally speaking, and I mean 99% of the time, I would say, if not closer to 100, do tell the truth. Because I find that the truth leads to growth and better outcomes for me. Well, actually, I guess it didn't in this, I guess me telling the truth led to me being cyber stalked within an inch of my life. Actually. So there's Mr. Thompson. As an opening statement, I'd like to address Mr. Thompson's role in this and my role in this as well as the plaintiff. On February 28th, 2021, I believe, I'm gonna have to cross-check it, I made a video claiming Mr. Thompson was a bully and that he should stop it. I said the words, come on, bring on the comments, do your worst. That is true. However, Mr. Thompson using that as a citation for being legally allowed to cyberstalk does not hold up. First of all, Mr. Thompson is a bully. There is a clear pattern of behavior that's well documented. I've already well documented it in my complaint. You can see exhibits C1, C2, and C3, C4. Clear pattern of bullying behavior. Also, if you consider the exhibit A, 1 through, I think it's, I did not have an exhibit for every single act of defamation, but some of them were based on memory, but the ones that I had on hand, I did use. So I have exhibits, Your Honor. I asked that the jury and the judge review Exhibits A1, in which Mr. Thompson has demonstrated insinuating that I maliciously and willfully killed a bird with clipped wings by throwing him off an 11-story balcony. Your Honor, that is not true. There is no evidence to suggest that that happened. Mr. Thompson made it up based off of an unfortunate incident in my life, and he used my own trauma to further abuse me maliciously, knowing, and I contend, that Mr. Thompson did not believe that I threw that bird off the balcony at all. Mr. Thompson wants to prove that he did believe that in good faith, then so be it. However, I would contend that Mr. Thompson knowingly accused, not just accused, but stated on some occasions that I did, in fact, throw a bird off the balcony. It's absurd on its face, Your Honor. My character, people that know me, it's just patently false, and there is no evidence to suggest I threw the bird off the balcony. I have no history of animal abuse. I would never harm an animal on purpose. As a matter of fact, the bird in question, which I had for 3 hours, and I named Flammy. So you're going to see in some of the evidence that's not in the current complaint, but will be further filed in future exhibits. Flammy is referenced. If you actually, Your Honor, if you look at the ex parte, request for judicial notice, you'll see in some of the exhibits and some of the images that were attached mentions of Flammy. So there was a mention of R. Flammy Kelly, which is a reference to this incident that Mr. Thompson alleges with no proof. Okay, then number 2, this lawsuit isn't real and that I made it up. Exhibit 2 demonstrates that after I filed the lawsuit, Mr. Thompson willfully ignored the truth, nor did any diligence to check or find out, and therefore defame me. He essentially attacked my credibility and attacked the truth, as a matter of fact, because I had filed this. This took place after May 5th, which is the date that I filed the lawsuit. It was about May 9th or May 11th. Offhand, I don't know. 3, that I did not file this lawsuit after I already had. So I would say that saying I made it up is one case of defamation, and then saying that I didn't do it is another case of defamation, both attacking my credibility, and they're 2 separate statements, and they're both in Exhibit A2. Exhibit A3, that I recklessly commit slander and defamation against individuals. Exhibit A3, Your Honor, I do not commit slander or defamation on anybody. I am not a proponent of such behavior, nor is there any documented evidence of me defaming or slandering people intentionally. To achieve the civil code violation of defamation or slander, there has to be malicious intent. Anything I've ever said that may have turned out to be not true, which, Your Honor, frankly speaking, I generally say what I know, not what I think. I will allege in certain instances where I believe that it's within my right to do so. However, that's not slander nor defamation. And I would ask that Mr. Thompson produce evidence that I slandered or defamed anybody. 4. Oh, no, that was 4. So 5, that I committed fraud in conducting my business Brett E. Snell's books in 2021. There are future exhibits that were exhibit, I think it's B. It's not that. Your Honor, there is an exhibit there. It's filed in the thing. I will get to it soon. 6, that I encourage frivolous lawsuits. Your Honor, I encourage lawsuits, not frivolous lawsuits. Why do I encourage lawsuits? I encourage people to stand up for their rights. I encourage people to acknowledge their civil rights and to not allow them to be taken. And the only recourse we have in this country, aside from illegal vigilantism, is the court system. So I encourage a diligent use of the court system in where it is applicable. Now, it is true that I encourage people, upon an alleged infraction or violation, I encourage a person to sue. That is my prerogative to believe that. I believe that the American people have been, deprived of their civil rights based on their non-ability rather to sue based on economic issues, and also, just it's not easy to file the paperwork, and it's hard. But I believe that when it's merited, that it should go. And I will also I want to put on record that Mr. Thompson's clipping of a video where I speak about lawsuits, I would like to ask the court to compel Mr. Thompson to produce evidence in the event that he contacted anybody at the Doheny Plaza where I live, where I reside, and to and if Mr. Thompson did not in fact ever contact anyone at the Doheny Plaza, I would ask the court to compel him to testify on such matter, as it caused me much harm, the situation. And the Doheny Plaza utilized one of Mr. Thompson's videos and insinuated that it was my video and used it against me. And it was a video about lawsuits. And that potentially is a separate civil matter, but a very important factor in this case, as we will see in the future. 7, homelessness imminent. Your Honor, I did in fact add that comment as an exhibit. I did not list it properly on this complaint, but it is there in the exhibits. There is a comment where Mr. Thompson wrote on my YouTube channel, or it could have been the Hollywood Laughingstock. They became quite confused at a point that homelessness was imminent. Now, why is that defamation? Well, if it's not defamation, then what is it? Is it a threat? I believe it was a threat, Your Honor. Also, I never was homeless. I never had to sleep on the streets. I had a hotel room for a month period in which I was restricted from coming into my building based on an issue that I would move is inadmissible in this court. However, I'll leave that up to the discretion of the judge. And nor do I believe that it is much of a factor. That I wear dentures and hair plugs. Now that's two separate. That could have been 8 and 9, but that is Mr. Thompson has stated both, and neither are true. I would move that 2 dental implants are not dentures, as a matter of fact. It's an incontrovertible fact that I do not wear dentures, which is neither a good or bad thing. Ideally, a person has their teeth, but it's a lie. It's a malicious lie meant to hurt me and harm me, both. 9, that I'm lying about having an ADHD diagnosis. Exhibit A9 demonstrates that Mr. Thompson insinuated or stated with malicious intent that I do not have an ADHD diagnosis, and I have exhibit, we'll say AB1 will be the active diagnosis from a psychiatrist, or a nurse practitioner, I believe, from 2021, in which I was diagnosed with ADHD. And it's currently active, actually. It's a current active diagnosis. 10, that I am lying about having childhood trauma. Upon request, I can produce an affidavit from my current therapist, most likely. Now, some people don't like to give affidavits because it makes them maybe have to go to court. Now, if you review my content, I have a lot of childhood trauma. So much so that it has made my life quite difficult, and I've struggled through it a lot, Your Honor. And I ask that the court put that under penalty of perjury. If I'm lying about that. So I have significant childhood trauma, not just childhood trauma, significant amounts. 11, that any attempt at good faith discussions were fraudulent on my part. That's quite the opposite, Your Honor. I'll testify that I almost, in fact, never engage in bad faith discussions. It's not in my nature. In fact, my nature is probably a little bit too much good faith, because sometimes I don't recognize when people are persistently acting in bad faith. 12, that I am an obvious and well-known liar. I contend that that is not true on its face. Ask Mr. Thompson to produce the lies. 13, that I blame him for all my problems. I do not blame Mr. Thompson for my childhood trauma, one of my problems. That said, I do not blame him for all of my problems. Yet him saying that was really did materially and immaterially harm my reputation, my relationships, and in my life. I ask that the court note the seriousness of such an allegation, especially where Mr. Thompson is concerned. 14, that I falsified a copyright for my cover of Mark Cohn's Walking in Memphis. As a matter of fact, Your Honor, I purchased the license to be able to release it on streaming platforms. I think it's, frankly, it's already a non-exhaustive list, Your Honor. However, I think that the court can review the complaint. The court has a complaint. I don't think it's necessary to state every single one, but I'll say this: if I was in court, I would go through the entire list, because some of the future ones are. Well, he said that I'm incapable of suing him because I lack credibility or any functional capacity to do so. I would say that that's patently false, because here we are. And 22, that I made attempts at hiding evidence. He insinuated I spoiled evidence. Or, Your Honor, I contend that Mr. Thompson, in fact, spoiled evidence. What's my proof? On the morning that the First Amendment complaint was filed, the 2 to 4 videos that were cited and linked, those videos became privated the very morning that my First Amendment complaint was filed. I contend that Mr. Thompson did so in some likelihood in order to avoid detection from the court or spoiled evidence to hide it. So I ask that Mr. Thompson produce those videos as well. It's an overwhelmingly non-exhaustive list. I'm going to take a little bit of a break here because that was a lot. But that's the beginning, guys. That's going to be the beginning. Okay? And that's literally not even getting to the Hollywood Laughingstock channel, which I think is important. Under California law, intentional infliction of emotional stress requires extreme and outrageous conduct by the defendant with the intention of causing or reckless disregard of the probability of causing emotional distress. Additionally, the National Conference of State Legislators defines cyber harassment as threatening or harassing email messages, instant messages, blog entries, or websites dedicated to tormenting individuals. I contend that the Hollywood Laughingstock channel was a blog or website dedicated to harming and inflicting torment on me, therefore violating a criminal code in which I urge the court to consider the referral of criminal. I urge the court to consider a criminal referral. However, the civil statute stands on, I believe it's intentional infliction of emotional distress at best. Offhand, guys, I'm not sure what the civil statute is. I believe that's a criminal statute. But I would suggest that if there's a criminal statute, there's probably a civil tort to go with it. Because like you could do a crime against somebody, like OJ, right? There was the first case, the criminal case, and then there was the civil case. And the civil case is when they melted his Heisman Trophy. So they took everything he had. It was a $20 million verdict, I believe. Every dime. Like, so he had moved to Florida, and so now he flouted a little bit. That's not even know that. So, Your Honor, I also ask that you, on Sunday, 6:22 p.m., Mr. Schultz is acknowledging a user, James Bartswell, who is, I don't know, Your Honor. I asked that the court unmask. In fact, before I will, by the time that we go to trial, I will have every single username unmasked, because there's a procedure which requires filing a separate complaint. There's like a fee, but I will have every single one. Brett has HIV will be unmasked. All of the usernames that have come in here and violated my civil rights by harassing me will be unmasked. Prior to court, so this week. So let's see what this person is saying. What did happen to the bird? Okay, what did happen to the bird? I found the bird in a fountain, drowning, literally, Your Honor. I was down at the corner of Doheny and Santa Monica Boulevard. That morning, I found this bird that I named Flanny. I showed him on live stream. He's a beautiful songbird. He was drowning in a fountain where the water came up to here and the thing was here. He was not going to make it if he did not get help. I don't know if birds can swim, it looked like he was unable to get out. So I ask this to be added to the record. I was not that comfortable with touching the bird at first. I wasn't used to it, but I saw an animal suffering, and I lifted him up, and then I placed him on the fountain area, and I wasn't sure what damage had been done to him. I was scared that maybe he had broken a leg, or I don't know, or had some sort of like painful. I don't know, but I didn't know at the time. He seemed okay. So when I sat with the bird, I basically loved him, and then he seemed to be revived of his. He seemed traumatized at first, and it was a beautiful bird. I took the bird. I walked all around the Beverly Hills area, and then I came back to my house. I had actually bought the bird food and a toy at Petco, or I think it's down the street, PetSmart, and I brought him back here. And we have a sliding glass door on our balcony. We live on the 11th floor. I left the bird. It seemed comfortable with knowing, where I was. I don't have. I saved this bird randomly. I didn't expect to have a bird. I did not. I wish that bird was still here. It was. I do. The bird was free. I did not have a cage, and I went to shower, and the bird. And when I came out, the bird was gone. Now I don't know what happened to the bird, to be quite honest. I don't know if this bird would have been capable of. Mr. Thompson has stated several times that his wings were clipped. I don't know, Your Honor, whether they were or not. Frankly, I don't know. I do hope I pray that bird is okay and still alive somewhere. I don't know if he would be able to glide, or I just don't know. But he was gone when I came out of the shower, and it was frankly a very confounding event. Like, I did not know. I was confused, and I'm hurt by it still. Actually, it's in retrospect probably more traumatic than that day, because I was so he came into my life and then he left, you know, and I wanted to keep him. I did actually, but he was beautiful. It was a beautiful, 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 beautiful bird that I really would have liked to have had, and it's frankly quite upsetting that that he was gone, because I don't know what happened to him. I did not hear of any I didn't hear of any bird bodies being found anywhere, like in the area. Like I don't know. Frankly, I don't know what happened to him. But it seems that he may have. Your Honor, frankly, I don't know enough about birds. It strikes me as strange that a bird would like choose to fly off of a balcony unless he could. Now, I don't know. Can a bird determine whether or not can? I don't know. So perhaps he flew and he flew away. Perhaps his wings weren't clipped. Frankly, I don't know. But that is what happened. Is that I left the bird and I left the door when the sliding door open. I was a bit negligent there, and I admit that, Your Honor. I could have closed it, and perhaps the bird would still be here to this day. I did not throw the bird off the balcony. I did not maliciously kill the bird, Your Honor. The defamational statement in question is not whether or not I was negligent and the bird fell off the balcony, so to speak. It's whether I threw the bird off the balcony, which, think about the connotation of throwing a bird off the balcony. That's essentially a psychopathic. You're being accused of torturing animals or killing animals. That's, Your Honor, that might be the worst of the defamatory statements. This is why I place it first, because it would speak to a character that is not mine and that has never been mine, and there is no proof that it happened anyway. None. Mr. Thompson was reckless, malicious, and incorrect. Is there another statute for defamation? Intent, malicious intent, incorrect, could not, okay, he reasonably believed that. Could he reasonably have believed that I threw the bird? Your Honor, there's no corroborating evidence. Yes, the bird was gone. Accidents happen. Mr. Thompson has no proof. There's no witnesses. There's no testimony. There's no video or picture evidence of this event. So could he have reasonably believed that I did that? No, Your Honor, because there's no proof of it, other than the bird having been gone. Your Honor, that's frankly not enough evidence for him to assert. It's reckless and it was wanton. He knows I didn't throw the bird, I would contend. And if he does think that, I would really love to hear why and what made him think I would do that. And then we can go from there. I asked Your Honor to take a 15-minute break so that I can calm down and collect myself. Thank you. Your Honor, one more thing. Mr. Thompson, I believe Mr. Thompson, asked, did you leave the balcony sliding door open? Now, Mr. Thompson did not state that I acted negligently and left the door open and the bird fell off by himself. He stated that I threw the bird off. Now, Mr. Thompson's asking of such a question insinuates what? He doesn't know, right? That he doesn't know what happened. And he's also trying to get an answer of yes, that I left it open. So which would mean what? That I acted negligently in terms of taking care of the bird. So if Mr. Thompson is trying to lead me into stating that I was negligent, well, the defamatory statement in question is not about negligence. It's about intentional malicious killing of a bird, essentially. So I would ask that Your Honor, that be added into the record that Mr. Thompson himself has essentially demonstrated that he doesn't know what happened and created it, the story that I threw the bird off. He created it. He created it. He is a liar, and in conjunction with the many, 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 many lies that he tells, I would ask that this statement be taken extra seriously, and that any damages, punitive and emotional compensatory, otherwise, be significantly higher for that specific statement. I ask that every statement filed of defamatory, I ask that it be determined individually. So depending on the gravity of the statement, I ask that the court decide on a statement by statement basis. There are many. It will and I apologize, Your Honor, but that will be difficult. There will be a non-speedy manner of adjudication because it's a lot of things to review and a lot of things to think. And I apologize, but I do believe that different statements have different values, and that needs to be in the record. Thank you, Your Honor. Thanks for the break, Your Honor. I don't want to go on much further. This is just practice, but I want to address the court one more time before we recess or adjourn for the day. In cyber stalking cases, there is and this is going to address Mr. Holmes, but also Mr. Thompson. There's a term called concern trolling. Now, concern trolling, I'll read the definition. It's the action or practice of disingenuously expressing concern about an issue in order to undermine or derail genuine discussion. And I would offer that Mr. Holmes has a couple things about Mr. Holmes. Prior to the incident or prior to my video on February 28th, Mr. Holmes had expressed, it's in the complaint, he wrote on my YouTube channel, I played a song, which I'll play for the court after this, so the court can decide whether the song is good or not. Mr. Holmes, who I believe also maybe have an alias Greg Char. I have to unmask it, so we'll see about that. Mr. Holmes commented the following on a 2018 posting to my channel. Mr. Holmes expressed support for my talents, musical talents, posting the following comment: more. You are very talented, absolutely wonderful. Subsequently, in 2021, sometime during the early phase of what would become a 2-year ongoing terror for me, Mr. Holmes and I spoke on the phone. I was hoping to diffuse the situation. He was potentially an intermediary. At that time, I wasn't fully aware that he was basically the benefactor, that he paid Mr. Thompson's bills. I haven't heard otherwise yet. I haven't heard Mr. Thompson state otherwise, or any other person that might know. So we spoke, and I would say that Mr. Holmes, Mr. Thompson do not, in my opinion, suffer from the same personality type or disorder or whatever it is. Mr. Holmes has the ability to speak in good faith at times. And I believe in 2018 that comment was in good faith. However, where Mr. Thompson is concerned, who is not his partner, they're not boyfriends or domestic partners. As far as I know, they don't live together. I don't, they'll have to contend with that. So Mr. Holmes seemed to have a blind spot, is what I would say, where Mr. Thompson was concerned. It seemed that it didn't matter how bad Mr. Thompson's behavior was or how overtly harmful. Mr. Holmes was incapable of acknowledging it. Now, it goes much deeper than that. Your Honor, if you look at many, so I've submitted many videos for the courts to review. And if you look at those videos, they're live streams in which Mr. Thompson, he solicits or accepts donations for his commentary. Now, these videos, some of these videos that may file under fair use, possibly, as Mr. Thompson is providing commentary, transformative purpose of it. However, I would ask the court to adjudicate the question: is defamation commentary? So, is defamation a prohibitor to fair use? Can you have fair use and defamation simultaneously? that a defamation is a civil statute. It is what it is. So whether or not but I would ask, if you're defaming while using a copyrighted article that you did not receive any permission to do so, is that fair use, or is that a malicious use? And Your Honor, I'm not sure that I know the case law, and provided that there isn't any case law, and by the time we're in court, I'll know. I would ask that that be adjudicated and declared if it hasn't already been, because it's important that fair use. Then fair use is part of this, because Mr. Thompson claims fair use, but Mr. Thompson's channel, which is currently named Held to Pay, and it was formerly known as the Hollywood Laughingstock, and it had a few different titles, uses nearly 100% of my copyrighted material in order to maliciously defame, libel. Libel is a big part of Mr. Thompson's channel, because the only part of the copyright that belongs to Mr. Thompson, in my opinion, are the titles of the videos. So the titles of the videos are often misleading. Even if they're not misleading, they're of a general tenor that can be construed to be malicious. So there are very many blatant libelous claims that in these titles, but fair use requires commentary or transformative use. Now, in my research of fair use, I would say that the instances of fair use, generally speaking, we're talking about using a percentage of like 10% or less in order to constitute fair use. Now, Mr. Thompson used in many of these videos, the videos contain 100% of my copyright. Now, the court will have to answer whether or not, if I did an hour live stream and he uses a 3-minute clip, does that constitute, I guess it would be what? 1% would be 0.6, so times 5. So is that 5%? Okay, so 0.6 times 5 is 3 minutes. Okay, so I would ask the court to clarify whether the percentage relates to the original work, or the potential instance of fair use. Is it fair use if all that is in this video is contained from my copyright without permission and maliciously used? Is that fair use? I would state no. I would state that Mr. Thompson does not appear in many of these videos. Mr. Thompson simply cuts videos of my copyright and posts them as though he owned them. Now, why do I say that he owned them? Because YouTube, their terms of service state that you own the content that you publish, or you're supposed to. And I would state that Mr. Thompson does not own any of my live stream material, and he doesn't appear in those. So it would be very difficult for me to see that Mr. Thompson is doing commentary. It's not commenting on it, because he's not like, all right, watching it. Typically commentary consists of a person watching a clip and then discussing it. That's not what happens in these videos. It's just all clipped of my own live streams. So I would ask that the court adjudicate whether this is an instance of fair use or not, first of all. I would claim that it is not. I would also claim that malicious intent is an immediate violation of copyright. If it's used maliciously, that it cannot be fair use, especially if it's also misconstruing or misleading or otherwise, in bad faith. Mr. Thompson, and there's the distinction. So In Mr. Thompson's live stream videos, he's commenting, he's talking about it. In the Hollywood Laughingstock channel, it's just me. It's all my content. It's like I literally, Your Honor, own the content used in that channel. Now, is Mr. Thompson editing to maliciously defame or misconstrue or mislead about me? Fair use. I would contend that that is a very difficult argument to make. Your Honor, I have not seen any instance of that being fair use. Now, Mr. Thompson asserts that he's cataloging my criminal behavior. Now, I would assert that Mr. Thompson would be able to catalog my behavior without publishing it. Now, if it's in fact a defense, Mr. Thompson claims that he is cataloging it in order to defend himself. I would contend that is a lie, and that Mr. Thompson has no a defense, Your Honor. When I defend myself against Mr. Thompson, I speak myself. I state the truth myself. That's a defense. A defense is not an edit of somebody else's content. It's just if you look into the, Your Honor, and I'm sure that you're aware of the fair use statutes, and I would say that the amount of which he used in the total, whatever he published, was too much of my content. Even if but Your Honor, even if he used 5 seconds and added a misleading title, I would suggest that is not fair use either, because it is not transformative. It is just reproduction. It is just publishing of my copyright, which is either way, whether or not the terms of service apply to me because I was under duress. There's no claim otherwise. There's no claim that it's YouTube's content if I'm under duress or otherwise. I would ask the court to consider that argument. And then I would ask the court to review the channel in its many iterations. There's many screenshots, a lot of defamation and libel. Well, I guess suppose in this instance it would be libel, since they're words published. That is the usual, is the main libel. However, also the editing of the videos. Mr. Thompson, Your Honor, I am a musician. And I like to play music on my live stream, as Mr. Holmes acknowledged. And I want to say one thing to Mr. Holmes before I adjourn. But Mr. Thompson, I'm sorry, Your Honor, I lost my train of thought. But I would also, I just would like to put forth concern trolling, which is a cyber stalking tactic. It's a recognized aspect of cyber stalking. Who is it recognized by? Social Media's Victims Law Center, which is an advocate for people who are victimized on social media. Your Honor, I would also appreciate that it be on the record that none of these agencies ever responded to my requests or inquiries, because none. And I would ask the court to, if the court deems that I did something wrong to the degree that I'm not entitled to any good faith, any help from any organization that's supposed to help people, because none of them helped me, Your Honor. I did try. And I went through a lot, Your Honor, a lot. And I would ask the court recognize that in the instance that the username Greg Char, in the instance that turns out to be Mr. Gregory Holmes, also known as Reamseed, in that event, that the following comments be assessed as concern trolling. I will read you the comments. should be. Your Honor, the reason I contend that this Greg Char is Mr. Holmes is that his name is Greg, and he discusses Mr. Holmes claims he's a professional musician. Your Honor, I have written 3 theme songs for internationally aired cartoons. I have released upwards of 30 songs on Spotify and other streaming platforms. I've turned down management contracts that have been offered to me because I did not like the terms. And I would contend that aside from the fact that there were years where I made in the thousands on royalties, but I've not necessarily struck it big in the music industry. But I would contend that I am a professional musician in that I deserve to be recognized. I have been recognized by my peers. So Teddy Geiger is a producer for Shawn Mendes, who's one of the biggest pop stars in the world. And in Exhibit AC1, you'll see from Miss Geiger, you'll see a message from Instagram that says, "You're amazing." Like and another one, "It's gonna be so fun working together." So I would contend, and this was in the time period that the cyber stalking began, and I would contend that the cyber stalking harmed my ability to. I was being trolled by so many aliases that I believed everybody could potentially be after me. So I would contend that Mr. Thompson contributed to the destruction of a potentially advantageous relationship. But I would also contend that whether or not I'm good as a musician is not up for debate. I am. I'm recognized by Miss Geiger was nominated for Song of the Year at the Grammys the prior year. So there's just no way that I would like it added to the court record that I'm an awesome musician, that I'm an awesome musician, as indicated by Miss Geiger's messages and Mr. Holmes' own words. So, Greg Char, in the event that this is Mr. Holmes, I would like the court to assess it as concern trolling, as it is. And there are many other instances of concern trolling. Mr. Holmes is not as psychopathic or aggressive as Mr. Thompson. However, he abets, and participates and pays money for Mr. Thompson to defame and otherwise humiliate, torment me, which makes him a conspirator in every sense of the word. I would ask that every person that donated be at least considered for conspiracy to commit cyber stalking, no matter if they stopped at any point or they didn't. I contend that Miss Veronica May addressed me at some time around when the lawsuit was filed and said that she had never cyber stalked me and that she would stop coming into my live chats. Now, Miss May is a cohort of Mr. Thompson, and depending on the discovery, what was revealed, she will be held liable regardless of her contrition. However, I would ask the court be mindful that she was contrite a bit. She didn't apologize. I would ask the court, So I would ask the court weigh the fact that she told me she would stop, and she did, and I haven't seen her, so I don't know if she's behind any of the aliases. But I would ask the court to recognize that upon execution of me filing the lawsuit, that Miss Veronica May did cease coming into my chats and stalking me. However, that Miss May contributed materially to the activities that are addressed in this lawsuit, cyber stalking. And however, she did strike a more neutral tone. She did provide more material and what seemed like good faith conversation. I will also admit, I asked that the court recognize that. I asked the court not charge Ms. Veronica May with cyber stalking because of I don't believe that there is enough because I believe there's enough good faith on her part in terms of conversing, at least to my memory, that she, honestly, I would not file, I'm not filing suit against Miss May. Not at this point. Depending on discovery, that could change. However, at this point, my memory, and I think that's important and relevant, it depends. I mean, if there's a discovery, they're planning to do something, then I can't prevent that. I can't prevent her from being criminally charged. However, my interaction with her, while vile, especially in the first 2 years up until the lawsuit came out, had much more substance and good faith than like it had any. So I personally feel she was not empathetic to me, but personally at this point in time, without a further evidence, I would ask that the court not prosecute Miss May, as she did strike a balance of understanding the law a bit. There was also, it's up to I will ask that the court review it, but note that Mr. Schultz did not feel utterly affronted by Miss May's behavior. There were times at which it seemed actually productive almost, and that enjoyed actually some of her conversation. And she seems like a smart woman. However, I will say that she did contribute, but I would also say that she's just a different circumstance, and it's just, my feeling at this juncture is that she should not be charged. Mr. Holmes, however, Mr. Holmes, there is a story where Mr. Holmes claims that he owes his life to Michael Thompson. Now, I would ask that the court do some diligence in compelling testimony about why that is, because I'm concerned. I have concern about why Mr. Holmes would say he owes his life to Mr. Thompson. It's frankly troubling. The story, however, that I've heard is that Mr. Thompson found Mr. Holmes in a near dying state, or in some sort of physical state and saved his life. Now, from my interactions with both parties, they seem very uncredible, non-credible. So I would ask that the court compel discovery on that issue. Is there a hospital record? Is there a preponderance of evidence that supports that notion that Mr. Thompson saved Mr. Holmes' life? And even if so, that does not, in my opinion, actually that's a subjective opinion. It's not really it's not admissible as a legality, but it is admissible as a demonstration of conspiracy, in terms of that they were so close that it is almost unreasonable to assume otherwise. It is absolutely, Mr. Holmes contributes financially on its face to the live streams on top level, well above every other contributor, well above. $40 increments, $40, 10, 40, 20, here and there. Now, I also would contend that there are other contributions. I would ask the court to look into how much of Mr. Thompson's life was funded by Mr. Holmes. Now, part of it is to demonstrate Mr. Thompson's insane, frankly, hypocrisy in maliciously attacking Mr. Schultz for not having a job, which frankly, at this point, isn't true. Mr. Schultz had a job in 2022 for the year and didn't like it, doesn't need the job, and doesn't wish to keep it. Mr. Schultz has no obligation to work, but Mr. Thompson is. I would ask that it be a character testimony or a character evidence that Mr. Thompson is willing to attack. It's actually a clear pattern in which Mr. Thompson attacks people for what he has done himself consistently. So I would ask that also the conversations about Mr. Schultz, I would compel the discovery of every conversation between Mr. Holmes and Mr. Thompson that have involved Mr. Schultz, the Hollywood Laughingstock channel, as well as the Omni Presents channel, as well as the D Live channel, because Mr. Holmes has engaged himself on his own volition in concern trolling. That is in the evidence, I believe B1 has examples of that. Let me just check. Frankly, Mr. Holmes does whatever Mr. Thompson wants him to. And Mr. Holmes, in the conversations that I had with him on the phone, suggested as much. I would also ask that the court look at all of Mr. Thompson's online accounts and decide whether or not they're all cyber stalking or designed to torment individuals. I would ask that the court look at Parking Lot Creeper, which is another one of his sites dedicated to harming and tormenting an individual who expressed duress, overt duress, without it is incontrovertible that Mr. Thompson was provoking somebody who exhibited duress about the provocations brought by Mr. Thompson, and therefore constitutes cyberstalking, the channel itself, and is copyright infringement. And I ask that the court, Mr. Ray, who is the victim, I believe, of that channel, will have to sue himself. Mr. Schultz is representing himself. Mr. Schultz is not interested in a class action suit at this time. Mr. Schultz has put too much effort and, frankly, doesn't feel comfortable creating a class, because a class means that there's going to be other opinions, and Mr. Schultz feels more comfortable asserting his own opinions and asserting what, and it is my right, and I will not, this is my case, and I will decide how I adjudicate, how I litigate it, rather. But I do believe I believe it was Exhibit B1. If you look at Exhibit F, you can see that Mr. Schultz's business that was derailed by Mr. Thompson's insane behavior and propagation. Also, there was a Mr. Fortune who also contributed materially to this propagation of fraud. I believe, I am nearly certain that Mr. Fortune contributed in such a way as to contact or conspire with another to contact my partner, Brett Easton Ellis, his agent, in order to intimidate me to close that business, which contributed greatly to the destruction of what was going to be a legacy, what was a beautiful and thought out, and I spent so many hours, I spent so much money, it was doing well. The catalog of SKUs were selling well. I made $3,000 off of one purchase on day one, Your Honor. It was a very viable business that didn't even have a chance to thrive or mature because Mr. Thompson decided to engage in a cyber stalking campaign I don't know that the courts have seen. Now, there was, so the courts, actually there are recent ones. There's the eBay case. So Mr. Thompson, I don't know the full extent of his activities, but I believe that they are many. I actually allege that Mr. Thompson, I asked that they look into the Discord, any Discord use of Mr. Thompson, and ask did Mr. Thompson ever create a username TM5.10? I think we can leave it at that for there. If he didn't, he didn't. But if he did, I asked that they compel discovery on any interactions with Discord or any engagement on that. And that means probably seizing his hard drives. And I would ask that the court acknowledge the spoliation of evidence that Mr. Thompson's already engaged in. Mr. Thompson has also engaged in a sort of redirection of his behavior in order to acknowledge mental health. That is only after he is duly aware. So he was aware, and then he was duly aware upon being served, where he's trying to strike a different tone. I would ask that the court not allow Mr. Thompson to simply change course now, not at this point, not after years of sickening and grotesque harassment. And Mr. Reamsey, Mr. Holmes, engaged with Mr. Thompson almost every time. I would ask that once we unmask, frankly, we'll know. But frankly, I would suggest that Mr. Holmes was in every time Mr. Thompson was raiding my chats. Mr. Holmes was there with him. And Mr. Holmes was also engaging in concern trolling, quite obviously. And I'll point to Exhibit B for that, but also Exhibits A, D, 1, 2, 3, and 4. Mr. Holmes was also duly aware, based on phone conversations and my reactions in live streams, that I was under duress and being tormented, and he participated in a very material way that very much was part of my suffering. I also asked, the court, we invoked California Civil Code as Mr. Thompson utilized DLive and YouTube in order to propagate most of his activities, and that those are both based in California. Mr. Thompson, if you read the terms of service, would have known that, and therefore, based on me bringing the suit here and YouTube being here, DLive being in the state, that we invoke California civil codes in every instance, and those be upheld. Mr. Holmes has himself committed libel, gaslighting, and harassment towards me. Exhibit B. I asked that the court look at Exhibit B to determine that Mr. Holmes was a participant, a material participant, not just in funding the activities, but in actually participating in the activities himself. And the closeness of the two, I think, is a further balance in the weight of Mr. Holmes being guilty. Well, I prefer to see criminal charges referred, but in civil court, I believe Mr. Holmes is liable for his conduct, and that each comment from Mr. Holmes is weighed heavier because of his participation in terms of funding the activities and his knowledge, his relationship, the nature of his relationship with Mr. Thompson, and that it was a coordinated attack that Mr. Holmes was probably, I allege, duly and utterly involved with, among others. I think that'll serve for the practice run today. Is that a threat? I'll also ask the court to deem YouTube's product faulty on its face by virtue of not offering sufficient tools for a person to pursue their unalienable right to the pursuit of happiness and use and cultivate a career or anything without being cyberstalked. So it's much harder to cultivate an audience if you can't speak back to them. So the preponderance of aliases on these accounts, it is unreasonable for the burden to be on Mr. Schultz to report every single account, which new ones come in after you ban them. You ban them, new ones come in. And Mr. Schultz has experienced many stages of grief over this, and I believe that is further evidence of it. And I also let the record show that somebody, most likely Mr. Holmes or somebody associated with him, stated the following on June 11th, 2023. Mr. Jones will drown you. So why are you even trying? Okay? I asked that be considered a threat. Drown means to kill. I also asked the court pursue YouTube and determine whether or not the following comment was ever stated in the live chat. We will eat your flesh. Mr. Schultz credibly remembers seeing that very comment. We will eat your flesh. Your Honor, speaking frankly, I find it extremely difficult for the jury. I would find it difficult personally, or for the judge, to find them not liable for this activity. It was malicious. It was intended. It was intended to make me homeless, which they didn't make me homeless because I have a partner who loves me and who, when I was temporarily unable to stay in my home, due to the paranoia and behavior induced by said paranoia that was heavily influenced by the cyber stalking campaign. Now, Mr. Schultz has experienced mental illness to some degree, back and forth, but when you cyber stalk an individual, that's why they chose me. Now, I ask that the court weigh even heavier in punitive damages because they're aware of Mr. Schultz's vulnerability, and it's also a pattern of conduct, which I've shown in Exhibit C1, C2, C3, C4. Thank you, Your Honor. I adjourn for today. Whether or not I turn on or off the chat doesn't give you the right to cyber stalk me in the chat. That indemnifies potentially YouTube, but not you guys. Potentially. Because YouTube will do in the next practice run. I already stated objections to immunity under Section 230 for YouTube LLC that are adjudicated in case law. There's case law to support that. Your Honor, thank you. Use it all, honestly. Oh yeah, I know. I think I'm in court. Come on, dude. Stop. This is not me. Live streaming does not constitute initiating contact. That's a lie. That's an absolute lie. It doesn't. You're initiating contact by putting a message there. I mean, listen, we're off court now. If you guys haven't figured out now that I'm a lot smarter than you, most likely, allegedly, then you're really, really dumb. Really dumb. And I don't know why you continue. I'm going to report all of this to the judge because this is your activity. You're intimidating a witness. Will drown you? What do you mean? I've tried to mediate with you. I've tried to bridge something. I've tried to advise you of my intent. Now, your intent to drown me is a threat. And go for it. Go for it. There you go. There's your invitation to do whatever you want to me, right? Because I said go for it, right? No. Stop messaging me if you're going to harass me. It's frankly, I believe that YouTube has defaulted on their reporting system. I believe it is faulty. It does not work. It is insufficient. It is abusive to the person using it. It is a lie. It is a farce. It does not work, and therefore YouTube also should be liable for all of the damages for conspiracy to cyberstalk and cyberstalking, due to the preponderance of evidence that they knew what was happening, did nothing, and then thus were offering material support, which is YouTube's platform and their software. And Mr. Schultz does not agree with the term of that I am. Also, Mr. Schultz would like to seek relief in the form of the statute that YouTube claims as a year. I would like YouTube to be held liable for the 2 years. Mr. Schultz was under extreme duress for the 2021 to 2022, and then and up until now has been under mostly consistent duress based on YouTube's faulty product. Mr. Schultz, in good faith, tried to cultivate a better environment, but was just not possible. The mental condition, ADHD, makes it difficult. Frankly, the childhood trauma makes it very difficult. Well, I suppose, I don't know. I mean, it doesn't make it difficult. Mr. Schultz is talking about Mr. Schultz. Their behavior is their behavior. It has nothing to do. It's really, I'm not liable for their behavior, right? But they're liable for the outcome of their behavior. So Mr. Schultz is not asking that you, and Mr. Schultz is not asking that YouTube be held as a speaker or publisher in the instance. Mr. Schultz is asking that they be considered a provider. They are a provider, and in that case, that they be adjudicated as such as conspirators. Or adjourn. Now, the YouTube is going to argue, Mr. Schultz had reasonable knowledge that using our platform would harm him, or using the live chat function would harm him. So then maybe you guys shouldn't have the live chat function, because you're aware of the fact that there's a reasonable probability that it's going to result in extreme emotional suffering. How about that? And the reporting system, we'll get into that next time. I can't even. This is why I have to sue you guys, because the way that you have construed me and defamed me has really harmed my reputation. And I'm going to fucking take it back. You're wrong. Has Brett let me out of the... You're wrong. You guys are wrong about me. I'll tell you that much. You're very wrong. And you're going to find that out if you haven't already. You're going to find out that, well, you already know. I mean, come on. I want the use of my live chat. I want the use of my live chat that is provided to me. I don't want it taken away from me by cyber stalkers. And if in fact that's the case, YouTube better do a much. They failed to warn. They failed to warn. They failed to do anything. YouTube could be in the live chat. They could have helped Mr. Schultz. They could have addressed these people doing it. It's clear that there are people behind this. This is not an anonymous case or a case of anonymity. It is clear what is happening. Is it my duty to moderate this? Is it? Maybe you think it is, but what if that's not possible? What if I can't? By virtue of the volume, by virtue of the malicious actors, you have not Twitch offers a verified email only, which and I'm gonna put this in court too, by the way, that the first 2 followers that I had when I started my Twitch channel, Omni Eris and Reamsey. That's because I had to use verified emails, which is why I know that. And that means you both who are being sued by me followed me onto another platform. Does that look good, do you think? And you do not get to, this is not initiating contact. I'm sorry. You're going to have to, you know what? If you are able to defend that, that will be case law. That would be a very interesting case law, I think, is to say that one can initiate contact without contacting anybody. Like doing a live stream, if you subscribe to me, that's not my fault, especially under all these aliases. How am I supposed to fucking block you out without complete? And I'm supposed to just be like, come on. Come on. Listen, I gave you guys like 2 hours or something. How long has it been? Just an hour? I gave you a lot of my case. I mean, you should really just, 2 hours. Like, give me a fucking break. You're clearly in bad faith. And I don't know what you're going to say to the judge, because the judge doesn't, I don't know. We'll see what the judge says. Let's see if the judge wants to, let's see if the courts want to blame me for my abuse. I think it would be akin to blaming a rape victim for being raped. It would be the exact same thing, actually. Not even akin. It would be the exact same thing. So I advise you to stop. Stop. I'm telling you, stop. And then I'm going to ask the court every single instance of harassment, every comment after being unmasked be weighted for punitive damages and statutory damages. Both. I want to be compensated emotionally for every comment, because every comment hurts. And I want them punished, punitive, as per the goodwill of the courts. And what they're supposed to do is punish criminals. Now, I believe in rehabilitation more than punishment. But I also believe in justice, in that sometimes punitive damages are a form of rehabilitation in and of themselves, especially to these types of people who know what they're doing and do it on purpose. I also move for summary judgment against all 3 defendants in totality. Thank you, Your Honor. What's up, guys? We're back to the react. Now that's it. That was our practice session. What do you think? Is there anybody that's not a? Is there anybody that doesn't want to? I don't know. I don't even know what to say anymore. It's like one day I'm gonna have a chat where there's like people that are like, some are decent. I'm not expecting everyone, but like, I'm expecting I won't be rated this way constantly. But I'll be able to live stream. I don't know where it will be. I would like it to be YouTube. I like YouTube in a lot of ways. I just don't. I think that they really dropped the ball on me. They really, really, really dropped the ball. And I don't know if they did on purpose. I do believe they did. Unfortunately, that's what I believe. I don't know, but I'd like to know. It seems as though they did. I suppose there's a term of service where I'm supposed to hold them harmless, but that's only an applicable outside of applicable law. And I've cited a lot of applicable laws that have been violated. So that's also the terms of service. So YouTube, I'm only speaking in applicable law. I'm not even. I know that because I've researched it. And Section 230 is already bursting at the seams. There's so much objection to it. It's really like it's only a matter of time before it's refined and narrowed in scope. And I had never done law school. God damn, it sucks so bad that all of you guys are fucking crazy. It sucks. It's so unfair. Why can't any of you just talk normally? Why? Why can't any of you just speak like a normal adult? What is wrong with all of you? What are you? Honestly, I've already told the judge what I think you're trying to do. You're trying to either put me over the edge emotionally so that I default on the suit, or you're trying to intimidate me into dropping the suit, which will not happen. And one of you, Mr. Holmes or Mr. Thompson, whoever said, I can't wait to countersue, it has to be Mr. Holmes or Mr. Thompson by virtue of the word countersue. You can't countersue someone who hasn't sued you. I can't wait to countersue. Was it Mr. Holmes or was it Mr. Thompson? And if it was, look, you're basically, in my opinion, an entity. And honestly, get ready to give your hard drives over to the courts because I'm going to be seeking all the evidence I can. So don't delete anything. I'm telling you, preserve the evidence because it will be abundantly clear if you don't. Because you don't know what I have and I don't know what you have, right? I'm ready to hand over everything I have, everything. I would fucking put my whole backup on here and just give it to the judge. And I would give it to you to look through. And it would be that's your right. Your right is anything relevant to the case is definitely your right. But at this point, you don't know what I have. So if you delete something and I have something, it's not on in the discovery, then you're going to be found in contempt. Probably you're going to be found to have been destroying evidence. Can you please stop? Okay, I think I'm in court again. Yeah, okay. What if I just jumped off the balcony? What if I just killed myself? Huh? What if that happened? What would you guys think then? What would you think then? Would you be happy? Would you feel that you were liable somehow for it? Or would you just... You would be liable for it. You guys are like seriously, like you have to leave. You basically shouldn't be typing anything at this point. Anything you say, if it's positive, it will be construed as concern trolling. If it's negative, it will be construed as cyber harassment, and that's it. So a due apology, I don't know. At this point, the suit's not getting dropped. So, I mean, a summons will be, sent out. Don't evade it. because you're duly aware. You should be served. As far as I'm concerned, you guys have all the documents. You should be served. Tell me how you hurt me, baby. You don't even have to say a word. Tell me I'm acting crazy. Tell me that I'm acting like a girl. Yeah. You know that I can't hold back. So when I feel bad, and you can see it easily. I know I can't change it. I know you can't change it. But do you know what it means? And I wanna scream when it hurts like this. Tell me, how can I hold back? How can I refrain? I wanna douse out the burning flames. So how can I put it, baby? How can I explain? I don't wanna be angry, no, but I don't wanna have to hold this within. I ain't gonna leave you, baby. Yeah. But I gotta tell you how hard it's been. You know that I can't hold back when I feel bad. When you can see it easily. You know I can change it. I know that you can change it. But do you know what it means? I wanna scream when it hurts like this. Tell me, how can I hold back? How can I refrain? I wanna douse out the burning flames. So how can I put it, baby? How can I explain? Tell me how you hurt me, baby. Oh, yeah. You don't even have to say a word. Tell me how you see me angry. Oh, no. I hate to see you, baby, when it hurts. Say it now. You know that I can't hold back. Oh, when I feel bad. And you can see it easily. You know I can change it. No, you can change it. Do you know what it means? And I wanna scream when it hurts like this. Just tell me, how can I hold back? And how can I refrain? I wanna douse out the burning flames. Yeah. So how can I put it, baby? Yeah. Oh, how can I explain? Oh, 'cause I wanna scream when it hurts like this. How can I hold back? How can I refrain? I wanna douse out the burning flames. So how can I put it, baby? How can I explain? I've gotta keep the calm, gotta keep the calm before the storm. I don't want less, I don't want more. Life is what I'm fighting for. Keep me safe and keep me warm. Oh, my life is what I'm fighting for. I can't part the seas, can't reach the shore. Then my voice becomes the driving force. Don't let this pull me overboard. I gotta keep my head above water, watch me drown. As the bottom reach you there, at the altar as I fall down to my knees. Don't let me drown. Yeah, don't let me drown. Don't let me drown. Someone asked me why I call for mediation so often. If you guys want to mediate, then that's the next step. But like I've never ever heard from you guys in good faith. So I find it a little unbelievable that we'll be able to mediate anything that involves telling the truth. This is co-written by a friend of mine. You don't know what you're saying. It's not just wrong, it's defamation. You don't even know what you're saying. It's not just wrong, it's defamation. And you don't know what you're saying. It's not just petty, it's defamation. I started my music career in earnest at 27 years old. I taught myself piano at 18 in the dorms at the University of Iowa. I played that piano for so many hours throughout my 5 years there. And I played with a grim determination. Some people said I was the best piano player they'd ever heard. But I didn't take it to heart. It was you hit the keys too hard from my ex-boyfriend. It's Bill telling me I would never make it in music. Well, tell Bill when he gets home that everything in life that you want is worth trying. I said, you don't know what you're saying. It's not just fucked up, oh, it's defamation. Now you don't know what you're saying. It's not just hateful, it's defamation. Tell me what I did. I missed the mark. When I sent you love, you only wrote me off. I wonder about every conversation. Is it just me or my imagination? They said that was a chosen agent. Don't you know, just a man taking my medication. And you don't know what you're saying. It's not just fucked up, it's defamation. You don't know what you're saying. It's not just fucked up, but it's a defamation. You don't know what you're saying. It's not just evil, it's defamation. Yeah. I made a deal with God. He said, find out everything about this life. To give love whenever you can. To be wrong more than I'm right. Oh yeah, I made a deal with God. He said that he'd always forgive me later. Oh, and even if I fucked it up so bad, oh, he would still be and have my back. He'd still be my savior. Yeah. I made a deal with God. Oh, I made a deal with God. And he said you could fuck it up real damn bad and still come home tomorrow, friend. I made a deal with God. I can't find a comfortable space, 'cause I'm too worried about what you might think. I thought that I might write it down, but it's never what I'm feeling, even when I try to give it a meaning. Oh, and I had a deal with God. He said that he'd always forgive me later. Yeah, he said you can fuck it up real damn bad and I'll still be your savior. Soon now I'll made a deal with God. Well, I made a deal with God. And he said, you can fuck it up real damn bad and still come home in the morning, friend. I made a deal with God. Oh, just try to be nice when you can. Tell somebody you love them, and maybe you can have this goddamn deal. It's all a bunch of bullshit anyway, if I'm being real. Well, I made a deal with God. Oh, sure, I made a deal with God. So even if you fuck it up so bad, I'll still be on your side and hold your hand. I made a deal with God. Oh, and if I fuck it up real damn bad, I still got someone to call my friend. 'Cause I made a deal with God. Honestly, retracting your message, Horton, whoever you are, that's a good idea at this point. I would, in my opinion, you guys, in my opinion, if you haven't really been doing what they're doing, stop now. Don't do it. It's not worth it because it's all going to the judge. I swear, it's going to be in front of the magistrate judge and the district judge at some point. So I just don't want you to get in trouble if you don't deserve it. If it just started, David Bucky, you might very well be held liable for what you've done. You have participated in it consistently, concern trolling, and all that nonsense. You guys have left me no choice. You cornered me against the wall. And I'm a fucking musician who's got to stream and play. You cornered me so that you said, get off. You think I'm going to get off the internet for you? You? Who the fuck do you think I am? Huh? Who the fuck do you think you are? You should not be allowed on the internet. And I'm going to ask the judge that you not be allowed to use the internet unsupervised for like at least 5 years. That's really, I mean, you are too dangerous on the internet. You're too dangerous. I'm sorry. You're too dangerous. I'm filing on behalf of myself, but I also intend for the public good in everything I do. And you are a dangerous little troll. And you're both. You're both. It really is both of you. And it really is the other one too. It's actually all three of you. Absolutely. It's absolutely a conspiracy of the three defendants right now and any future defendant that's named. I don't know how you can avoid that. There was too much notice, too much negligence. The negligence added material support. Is that civil conspiracy? Had to be intent. So and then but like let's see the communications. I mean, if you left me hanging and you just depended everything on like AI or something, what's the intent? Not to help anyone. It demonstrates that you don't care. Now, or you could say, oh, it demonstrates that we know we need to help everybody because we have 500 hours of content. Well, if that's the case, then maybe you should limit the amount of content you allow up, or like do something about the, think about it. I know it's a good place for everyone to get their message out, but maybe you can have two, but you got to moderate. You have a duty to uphold good faith moderation. And frankly, I have not seen any of that. And I don't know how you're going to prove that either. What are you going to say, YouTube? What are you going to say? You're going to say that you protected Jake Paul or something? For example, who have you protected? Who have you come through for? Who have you laid the law down against? Who have you told you're not allowed to use our platform anymore and we won't allow you because you have promissory to estoppel or for estoppel, either 2 or 4, which is a big deal, which is your Section 230 immunity gone unless you fulfilled that promise. And if any of these people have been banned, or even if they're using aliases, you didn't stop anything. It was you know about this. So I don't know if your legal strategy is hiding behind one of your clauses in your TOS, but honestly, when you're being defamed constantly, you defend yourself. As Mr. Thompson likes to say, you need to defend yourself. So what am I supposed to do, YouTube? Huh? Am I supposed to let everyone just say shit about me all the time? Or are you just going to contend that all the shit they say about me is true? Or are you going to what? I don't know. Are you going to countersue me? Are you going to... Who knows? YouTube, I don't know. I don't know what you're going to do, but all I know is that it sucks what you guys haven't done. It sucks that I sent you a complaint, illegal. Do you know how hard it is to file a lawsuit? And then you just ignore it and say we can't do anything without a court order. What about your terms of service? Isn't that proof that you completely don't care about your terms of service? The fact that you only rely on a court order demonstrates a clear pattern of conduct. Just in that one incident, it's a clear pattern because it shows that you got a complaint in court and decided that your terms of service, you just forgot. You forgot. You also thought I was an idiot, or I don't know. Maybe you thought I would fucking boil over. I have a life that I intend to live, that I intend to be successful at, and I intend to be really successful, bigger than anybody. And I'm not giving up on that. And YouTube, you're one of the biggest platforms. So why wouldn't I fucking use it to stream? And if you're going to say that I lose my ability to stream because I'm being cyberstalked on your platform, I don't understand that argument, frankly. And frankly, God, you have billions of dollars. You could have just done one thing. You could have come through into a live chat with a fucking moderator from YouTube and said, this is YouTube official. Then you prosecute them. You should prosecute them, YouTube. You should be prosecuting these people. Not me litigating it. You should be litigating this shit. Not me. What are they? God, stop it. Dude, nobody's a nobody. Stop saying that. Stop saying that. Nobody is a nobody. Not even you. Nobody. Everybody's a somebody. Stop saying those things. It's cruelty. And honestly, I am a somebody. I'm famous to some degree. You're going to be famous too, though. Don't worry. You'll probably be on my Wikipedia page one day. But you seriously suck. And I don't like you. And I'm talking to both of you. And I'm also talking to all of the cohorts. Honestly, I don't know why you thought what you were doing was okay. Never made sense to me. I honestly couldn't believe it for months that this is what was happening. I don't think you have any argument. I mean, we're talking months and months and years now. Years of abusing a person, there's no defense. None. There's going to be partial summary judgment at least, because there's no evidence that I did anything to you guys. None. And Mr. Holmes, I'm allowed to talk about you in good faith and say what I think. It doesn't give you the right to concern troll. You fucking overgrown baby. You don't even know the law, dude. You're Brett's age. Get a grip. It doesn't give you the right to harass me. You can speak on your own channel and say what you think, and you did in your review of the shards, which I find to be highly defamatory based on your situation. You're just, I don't know. You thought, yeah, that's how angry I am, is that I squeeze my phone. Dude, it doesn't take talent. I know I'm speaking to nobody, but I'll say one last thing. It doesn't take talent to be a somebody. Everybody deserves respect. Everybody deserves to be treated like a human being, and that means to be treated with honesty, some care, and truth and justice. And so when you hear someone saying something about you that you don't like, you need to. I'm starting with the man in the mirror. Ooh, yeah. I'm asking him to change his ways. Look in the mirror and see why maybe I'm saying what I'm saying. Just think about it for 2 minutes. Read the complaint. Sign a waiver of summons. Let's just get this over with. It's like enough.